Ready, start. Hard-learned senior counsel appearing for the parties and perused the record. We consider it appropriate to begin our analysis by addressing one of the arguments raised by Mr. Chakrabarti. He has challenged the very maintainability of the application filed before the High Court. According to him, once an application under section 439 within bracket 2 CRPC seeking cancellation of bail has been rejected by the sessions judge, a second application under the same provision cannot be filed directly before the High Court. Instead, the proper course would be either to challenge the sessions judge's order in a petition for revision or to invoke the inherent powers of the High Court under section 482 CRPC. We are unable to agree with this argument. We note that in the present case, the application before the High Court was filed under section 482 read with 439 within bracket 2 of Code of Criminal Procedure close. That being the case, nothing prevented the High Court from exercising its inherent powers. We now propose to proceed with our discussion on the other aspects of the case. Law is well settled that cancellation of bail is distinct from revocation of an order granting bail. Bail may be cancelled when the accused violates any of the conditions imposed. On the other hand, an order granting bail can be revoked if such an order is found to be perverse or illegal. In P versus State of Madhya Pradesh, a 3-judge bench of this court, after analyzing various previous decisions, discussed the distinction between the two. Therefore, the concept of setting aside an unjustified, illegal, or perverse order is different from the concept of cancellation of a bail on the ground of accused's misconduct or new adverse facts having surfaced after the grant of bail, which requires such cancellation, and a perusal of the aforesaid decisions would present before us that an order granting bail can only be set aside on grounds of being illegal or contrary to law by the court superior to the court which granted the bail, and not by the same court. As can be discerned from the above decisions, for cancelling bail once granted, court must consider whether any supervening circumstances have arisen or the conduct of the accused post grant of bail demonstrates that it is no longer conducive to a fair trial to permit him to retain his freedom by enjoying the concession of bail during trial. To put it differently, in ordinary circumstances, this court would be loath to interfere with an order passed by the court below granting bail, but if such an order is found to be illegal or perverse or premised on material that is irrelevant, then such an order is susceptible to scrutiny and interference by the appellate court. In the present case, the High Court revoked the orders granting bail after noting that the Sessions Court kept only two considerations in mind: period of custody and no opposition from the prosecution close, without a discussion of the other factors in detail.